My colleague has, Minister Sominaden has explained about the purpose of the amendment. But I feel I need to clarify from what Honorable Utim and Honorable Mohammed have said. On the other hand, identification function involves the recognition of an individual by comparing the submitted biometric characteristics of one person with all previously submitted and stored biometric characteristics in a database throughout a search. This search is referred to as a one-to-many comparison. Let me go on so that the population should understand. The plaintiff does not contest the taking of his fingerprints and the storing of the data within the biometric card itself. What he contests is the recourse to the identification functionality, which will always need the existence of a database with the biometric data stored for comparison. It is contended that the identification system, and here I do emphasize, using the MNIC register as a database does affect the plaintiff's constitutional rights inasmuch as his biometric information and fingerprints will be in the possession of defendants number 1 and 2 and will be stored and retained in a database for which the defendants number 2 is the data controller. This is the point that I made before the Supreme Court. I have never been against storing those information on the national identity card. Why? Because the card is in your possession. It is part of yourself. It is as if it is your finger and your face. And as long as it is in your possession, I have never had, and I do not have, and I will never have any problem with that. And this is what is stated here. I would recommend, maybe he has forgotten, maybe they have forgotten. I think they should go and read this judgment that was delivered in my case. The Privy Council quoted against the Supreme Court saying, storage and retention of the fingerprints were not reasonably justifiable in a democratic society under Section 9.2. Storage, as I stated, in the database. So, again, to complete this part, it held that the storage of the data was not sufficiently secure because the safeguards of the Data Protection Act were not sufficient and the storage of the data was not subject to judicial scrutiny and control. I don't want to read there's quite, very interesting, very nice, I must say, not because that it was in line with what I have stated before the Supreme Court, but I think it has made jurisprudence, and the Privy Council therefore supported the finding of the Supreme Court. Now, the Honorable Utim had mentioned something with regard to, again, other information that could, let's say, be contained. Now, Madam Speaker, let me say something. And that is also not contradictory with what I have stated with regard to the contest, with regard to the dispute that I had with regard to the system that was being put previously. The population, Mauritius, will realize that the government of Dr. Navin Ramgoolam had spent, what, some 1.2 billion rupees for this project. 1.2 billion. I don't want to go into politics, whether this is justified or not. Forget about that. We have lengthily commented on that. Now, what would you expect this government to do? We come and say, we scrap this national identity card. That is a loss of 1.2 billion rupees outright. Or as in line with our thinking and our action before the Supreme Court, that we are against the storing of those information permanently in a database, because that we have to be very careful. But I must say, even that, the Privy Council has some view on that issue. But anyway, the first thing that when we came to government, the first thing that we did was to destroy this permanent database. And now, what is being done, clearly to me, is perfectly legal, is according to our constitution, according to law. And now there are some people outside this house saying that, and you have misquoted, I mean, not misquoted, you have quoted from, Honorable Utim has quoted from newspapers report. I maintain my stand. I maintain everything that I have said, not those reports, because what I was contesting was that you can't store it in a permanent database for the previous government when there was no security, and when you said ICAC, well, forget about ICAC and police. We know those days what could have happened. I said what could have happened. I'm not saying, I'm not accusing, but what could have happened under the previous government. This is the point that I was making, and this is what I have stated in the press conference. So I hope that this has enlightened the House, and therefore, Madam Speaker, it is our duty, in fact, to see to it how best we can use this national identity card today for having cost more than 1.2 billion, because we don't add up the ongoing expenses with regard to the setting up, the issue, the cards, and so on and so forth.